All right, hi everybody, welcome back. Attorney Steve Vondran. Got another exciting case for you today in the area of photo infringement, and this applies the statute of limitations and the discovery rule, two very important concepts. All right, this case comes from the district court from the Western District of Missouri, the Western Division. All right, so this is a case where we have a photographer, plaintiff, and we have a media defendant. And somebody is being accused of taking this wonderful photo here of Katie Sowers on the field at the 49ers game. It says here, plaintiff is a professional photographer. I just need to make that clear. Takes a lot of photos, this, that, and the other. And they found this photo being used, apparently, and I should also mention that the photograph is registered with the United States Copyright Office. In order to file a lawsuit in the United States, you have to have that registration first. But there is also a small claims court. I can tell you that in a separate video, copyright small claims. All right, so the crux of the argument is they posted this video and they didn't have the rights to the photo and filed a lawsuit for copyright infringement, very typical type of photo infringement claim. And the defendant had a defense of the statute of limitations. They said defense, copyright law, the statute of limitations is 3 years. But the most courts apply the discovery rule, which means it's 3 years from the date you discover or in the exercise of due diligence should have discovered the infringement. So it's not just a straight 3-year claim. So it's when you discovered it. Say, for example, somebody infringed 5 years ago and you're a photographer and you just now found it, or you're just getting into protecting your rights and you just now found it. You haven't filed a lot of other lawsuits. You say, well, it's a statute of limitations. I just found it, though, even though it's 5 years ago. It's within 3 years when I discovered it. And that can be a factual issue, could be a very contentious issue. Here, the defendant states that this was posted in 2017, the image. Why didn't you find it earlier? You're a professional plaintiff, what we call the professional litigant. There's other names for certain types of plaintiffs, but I won't go into that here. Anyway, so this was the case. The defendant cited the Petrella case, says the Supreme Court held that a claim accrues when an infringing act accrues or occurs. That's Petrella versus MGM. That's up in front of the Supreme Court right now, by the way. So I won't go into that, but I will be posting a video on that very shortly when the Supreme Court rules. And also, it's important to note, as they alleged here, each time an infringing work is wrongfully used or distributed, a new claim occurs. So the way this works, say that you're a photographer and somebody infringed your photo 5 years ago. Well, the statute of limitations would say you only have 3 years to bring it because the claim accrued 5 years ago when they infringed by posting the photo. However, most courts follow the discovery rule. And what the discovery rule says is the claim doesn't actually accrue until you discover the infringement or in the exercise of reasonable due diligence should have discovered. And that's what this case is about. So defendants trying to wiggle off the hook here and say this was posted in 2017. And they also stated the reason why we say this is you sued on this exact same photo. You've sued other people for this exact same photo. So how did you not find us using the photo? They allege they believe they had a license, but apparently that wasn't the case as far as I was able to tell here. And because of that, the court said, okay, the court says, here plaintiff filed the instant action on August 15th, 2023. All claims that plaintiff alleges in her complaint occurred no later than 2017. Therefore, following Section 507B, as in biscuit, plaintiff would have needed to file the instant action on or before. And then it goes into, indeed, many courts, including the Eighth Circuit, have adopted and applied a discovery rule. This is what I was just talking about, in which the statute of limitations starts once the plaintiff has discovered or with due diligence should have discovered the infringing act. All right, there's a couple cases here. Defendant, among other things, argues that she did not discover the alleged use until 2022. Remember, this is kind of a factual issue now. Well, she didn't discover it. Is it true? Is it not true? Should she have? Regardless of the plaintiff's allegations, plaintiff should have, with due diligence, discovered the allegedly infringing acts more than 3 years ago because since 2018. Plaintiff has sued, get ready for this, over 250 defendants over the use of the same Sowers photograph. So what the court's saying is you sued everybody in town. You must have scoured the internet up and down and left and right, down every crook, nook and cranny. And how did you not find these guys? Somehow you didn't find them until years later. I find that hard to believe, according to the court. So it says here, that's about it. But the court says here, while plaintiffs searched, she did not discover it. The BuzzFeed, this was BuzzFeed and I believe BuzzFeed and Vox were being sued. Court finds that plaintiff could have discovered BuzzFeed's usage before August 15, 2020 through due diligence, because at that time plaintiff was already searching for unauthorized usage of the Sowers photograph, which is evidenced by the multiple lawsuits plaintiff has filed. At this point, what I call the professional litigant, plaintiff has filed several lawsuits specifically with request to the work of the photographer, allegedly infringing work in this case. Cite some cases here, holding that the plaintiff had previously filed 20 lawsuits, including 2 related to the same photo at issue that it should have discovered within the limitations period. Okay, so the court's not really buying this. They're kind of saying, hitting them hard. If you're looking and you're trying to find your infringers, you better find them all at once or risk having your case dismissed under the statute of limitations discovery provisions. Okay. BuzzFeed published the photograph on their website in 2017 before the first lawsuit by plaintiff was filed. Plaintiff was actively searching for infringing uses of the Sowers photograph, and by 2020 had already sought to protect her copyright in that photograph 4 times from local and national media outlets. Plaintiff provides no explanation as to why searching for infringing uses of the Sowers photograph during that time, plaintiff would have been unable to discover a national media outlet like BuzzFeed using their photograph. All right, so there you have it. They tried to cite the Michael Greco case, another famous litigant, I would say. But that's what happened. So the court dismissed the case. They said, I'm not even going to give you leave to amend. That's it. Have a nice day. Case closed. And another big win. Photo infringement on the statute of limitations. So it's something to keep in mind. It's not going to apply in every case. You're not likely to be able to make this argument in every single case, but where you have a person that has sued for these particular photos over and over and over again, don't be surprised, and don't forget this is a case to be taking a look at. So again, this is general legal information only, not legal advice. I hope that provides some insight to one potential defense in a copyright photo infringement case. All right, Attorney Steve Vondran bringing it to you here. Guys, I hope you have a great day, have a great week. We'll be back with more great videos. Make sure to subscribe. And again, this is general legal information only, not legal advice.